Good evening, everyone who is here on March 16th and anyone who is watching this later. On behalf of the Diversity and Inclusion Committee, chaired by Daryl Tarver and Pilar Nichols, welcome. My name is Nina Basu, and Otis Friedman and I chair the D&I Events Subcommittee. We are excited to bring this panel to Legal Excellence Week. I Can't Connect, Finding New Ways to Forge Connections. So many of us have spent the last 2 years on Zoom as we're here tonight. Tonight's panel addresses the challenges and the opportunities from the use of technology for remote hearings. Tonight's panel is moderated by Chief Judge Retired Mary Ellen Barbera. Chief Judge Barbera is a graduate of the University of Maryland School of Law. After graduation, Chief Judge Barbera joined the Office of the Attorney General of Maryland in 1985 as an Assistant Attorney General in the Criminal Appeals Division and became Deputy Chief of the Division in 1989. In January of 1998, she joined Governor Paris Glendening's Office of Legal Counsel and Regulatory Affairs, serving as Deputy Legal Counsel until her promotion to Chief Legal Counsel in June of 1999. In January 2002, she was appointed an Associate Judge of the Court of Special Appeals, a position she held until September 2008, when she was appointed to the Court of Appeals. In July 2013, she was appointed Chief Judge of the Court of Appeals by Governor Martin O'Malley, becoming the first woman in more than 300 years of history of the court to hold the position of Chief Judge. I'd like to turn over tonight's panel to Chief Judge Barbera.
Thank you, Nina, and good evening, everyone. Welcome to the Maryland State Bar Association's panel discussion, the title of which is I Can't Connect, Finding New Ways to Forge Connections. As mentioned, I'm Mary Ellen Barbera, recently retired from the Court of Appeals and your moderator for this evening's discussion. None of us has been immune to the numerous challenges, personally and professionally, brought by 2 years of dealing with the COVID-19 pandemic. The stressors have been many, including our having to navigate our lives without reliance upon day-to-day in-person communication with others. We recognize the need to pivot to other forms of communication with the outside world. Among other methods of communication, phone calls, texts, emails, and social media, we knew or quickly learned to know exactly how the world of business, whether it's corporate or government related, or the business of the judiciary or the Bar Association, we have turned more and more often to virtual communication that allowed individuals to participate with others in large or small groups. And this virtual communication has brought us together to meet, listen, and discuss tonight's topic. For example, virtual meetings have addressed numerous issues addressing important matters that may have been difficult to bring to resolution without virtual communication. Certainly, the issues related to our system of justice run up against obstacles that may be impossible to surmount without virtual communication. Tonight's discussion will bring forth some of those obstacles, and we hope to I hope to solve some of them. So with that, I want each of you to know that we have an outstanding panel for tonight's presentation. And I had the opportunity to look through the resume of each of the 4 of them. I've been told that I have to limit it a bit, but I would love to be able to share with everybody the many, many wonderful things that opportunities, leadership positions, and so on that these 4 fabulous people have used and benefiting the population that they serve for so many years. I'll start with Natasha Dartig, who is now and has been since 1996 serving as Deputy District Public Defender for District 1, which is Baltimore City. She is, she essentially supervises everything that goes on working with the director, but she has many responsibilities supervising the attorneys, the investigators, support staff, and others, and she has outreach opportunities to others within the justice system. So she's done remarkable work as a leadership within the public defender's office, but that is not all she's done. She is very active in numerous bar associations. I won't list them all, but you can guess, State Bar Association being one, Monumental Bar, another, and the Bar Association of Baltimore City, as well as the Women's Bar Association. And she is committed to community work beyond that of the day job. I don't know how she does it, but she does. And she's really been, as one need only glance at the length of her resume, to be is in awe. I'm in awe of all that she's done. And no surprise, she is a wanted speaker, not just locally or state, but nationally, and has had more than a few of such speaking engagements as one can imagine. And finally, she is eager to work with and does work with the community in other ways that are beyond bar associations. So with that, I will give you the wonderful, indefatigable Natasha Dartigue. Next on the hit parade is Pilar Nichols. Pilar Nichols is currently with the law firm of Offit Kerman. She specializes, I believe, in family law and domestic violence issues and so on. I know that's not the exclusive scope of her work. She is, again, a wanted speaker at various bar association events. She, again, is a committed leader of a number of bar associations. Her work is spectacular. I've come to know her through the Hispanic Bar Association, the State Bar Association, and other opportunities when she was with one of the local firms in Montgomery County. That's how I got to know Pilar. So I am very excited and look forward to her comments this evening. She too, like Natasha, has been the recipient of more than a few recognitions over time, including a number of awards. And we're all very proud of Pilar as well as we are of Natasha. Turning next to Amy Petkosik, who is the Deputy Director of the Legal Aid. And what can one say about Amy other than that she, like the other two amazing women I just spoke briefly about, I wish I could have said a lot more, but Amy she is an innovator. She thinks beyond the box. She reaches for the stars on every project that she is associated with, and she leads some of them through Legal Aid. I can't imagine how she spends her days, much like, again, her sister lawyers, Natasha and Pilar. But again, I must say, award recipient. She started off as law clerk to Sally Atkins, Judge Atkins. That's where I met her. And ever since, she has just grown larger than life in the work that she's doing through Legal Aid. So again, I could say much more, but I dare say that we have other things that we need to discuss. So I will move next to Greg Wells. I should say His Honor, Greg Wells. He is currently a judge of the Court of Special Appeals. But lest you not know already, and I don't think it's secret, it better not be, because I'm going to say something about it right now, that Governor Hogan has designated Judge Wells effective April 14th, 2022, to become the next Chief Judge of the Court of Special Appeals of Maryland. I dare say it is the hardest working court in the state in terms of numbers of cases that the court manages, and he does great work. I've witnessed it. I've seen it in his writings, and it is it's outstanding. Of course, he's also had a career in which he's been a state's attorney, a master of juvenile, and I believe, I'm sorry, I don't have it right in front of me, but yeah, you'll correct me after this. And he created a drug court. He managed, when he was in the district court, to be the judge of the district court for the 3 most southern counties in Maryland. I don't know how he did that. I guess he didn't sleep. So another person of whom I must say, I don't know how the Bar Association found these 4 people to present on this very, very important topic this evening. So with that, I will conclude my introduction and my introductory remarks of the 4 panelists, and we'll turn generally to, if we may begin with, what are the challenges that confront you? And I'll turn to you first, if I may, to Natasha. The challenges that the COVID has wrought that causes the difficulties that one might have as a public defender. The work is difficult in times that are pre-pandemic, when we haven't had to pivot as we did do, and I hope we're emerging, but it's been a constant challenge. And of course, there's what any good lawyer wants, is to be able to satisfy his or her client and to get the result that is important to obtain. But there are challenges associated with this. And I know Natasha you're not the only one of the panel members who's been through this in one way or another, but you're perfect to start off the discussion with sort of your general notions about what you and others have had to overcome. And certainly in your leadership position, you have to be concerned not just for yourself, but for all who work for you in Baltimore City. So let me turn that over to you for your initial remarks, and we'll see what others have to say after that. Please.
Thank you, Chief Barbera. Let me first say thank you for your very kind remarks. And I say good evening to Chief Judge Designate Wells, as well as my esteemed female colleagues on this Women's History Month. I'm very proud to be part of such an impressive group. So I'll begin my comments by saying, speaking about the obvious, when March 2020 came about, we were all hit with the unknown. And being in this legal space, we really thought about how we were going to immediately pivot to make sure, to the best of our abilities, that people are going to continue to have access to justice. And the natural turn was to technology, of course. But in that moment, we did not really think about what would be the collateral consequences to the public that we serve. And I will speak particularly about the public that the Public Defender's Office serves. And we serve the disenfranchised. And I give the example in Baltimore City, one of the communities that we serve is Sandtown, Winchester. And I use that in particular because that is the community from which Freddie Gray came. And many of us throughout Maryland, as well as throughout the nation, are familiar with that area. And that is an area that's less than about a half square mile. Population is approximately 95% African-American. The average citizen in that neighborhood, 46% have a high school diploma or equivalent, and about 26% have less than a high school diploma. So you think about economically the dynamics of that. And when we shift to technology, for you and I, those of us who are practitioners, it was an easy shift, right? I think about myself personally. I have my laptop, I have my iPhone, I have my iPad, and if all that fails, then I have my son's Surface. Not to mention, I have high-speed internet. And we don't think about, the communities that we serve. Essentially, those essential pieces were missing. For me, in particular, some of the challenges that we face at the Public Defender's Office is even having some initial contact information. We at the Public Defender's Office do not do the initial intake. Those who are seeking services from the Public Defender's Office essentially go through intake through the commissioners. And the commissioner is essentially, their main duty is to assess whether or not the client meets the threshold income level. So there are times when we're not receiving all the contact information that we would need. So for example, we may have a name, we may have an address, but we're not necessarily going to have a telephone number. So you think about when we're making this shift to technology and we have to reach out by phone, or you hope someone has at least a phone so that they can access technology that is not existent. The other part that, when we made the quick pivot that we didn't think about the collateral consequence is just the use of the technology. I can speak for myself personally. Prior to the pivot to virtual hearings, I was not using the Zoom platform. I was not familiar with any, I didn't really use Microsoft Teams. I didn't really use Google Meet, but I had to quickly learn. And we think about the community I just described, where approximately 75% have barely a high school diploma. You're pivoting and having them being engulfed by this technology of which they are not familiar. Not to mention the fact this is a community that already has a distrust of the criminal justice system. So, there was so much that was thrown out so quickly, but yet, that was a viable solution when we could no longer come together in person. So what's been important as we've gone through this pandemic and as we move to the future, because there are definitely numerous advantages to using technology, how do we make account for those particular considerations?
Mm-hmm. Okay, I think that really is a great start for this discussion. And we led with you intentionally, Natasha, because you day in and day out have a community that you serve that has challenges. And in moving to virtual meetings, virtual hearings, just the contact, forget virtual, it's the contacts otherwise are also problematic. So thank you for informing us of the extent of the challenges that you and those you serve meet every day. And I can imagine too that Pilar, in some instances, you you have similar challenges. It's with virtual communication and otherwise. And also would like to have you speak just a bit about what the context we should be thinking about when we're talking about virtual hearings. How do we use them? What do we do to facilitate getting the job done now, certainly over the last 2 years? And congratulations, by the way, to all of you for the hard work during those 2 years. And let us hope, please, that we don't have much more coming down the road that's going to be anything like what you have survived, and you've done more than that. So Pilar, back to you. What do you think are the challenges for virtual communications, and how do you think they should be used if on the occasions when you can actually make it all work?
Well, first, it's my honor to be here with you, Chief Judge Barbera. Congratulations to Chief Judge Designate Wells, and it's an honor to be here with these amazing and accomplished colleagues. So it's interesting because there's so much good that has come from these virtual hearings, but then there are also quite a few challenges. And I think that by and large, if we work together, we can make it so that we can overcome these challenges and make it more accessible and just smoother for everybody, while taking advantage of a lot of the benefits. So I will, one thing I am going to share with everybody is a study that was done. It was, I put the link in the chat, and it was done by the National Center for State Courts and the Court Consulting Division, or their Court Consulting Division. And it is actually a study, and the State Justice Institute. And it's a study of the use of remote hearings in Texas. And it states the impact on the judicial workload. And it's a very interesting study, and it essentially mirrors everything that we had all been discussing when preparing for this presentation. And it's clearly something that transcends different states and things. So first, I would say that the biggest challenge, well, I'll tell you that the challenges are very different. They're very different when it comes to the challenges for litigants, the challenges for the attorneys, and the challenges for the court. And they're all things that can be overcome, but they all are very different. And so with regard to litigants, obviously technology, we just, that's going to be one of the things that everybody always touches on. And one of the things that's a big issue is that many people, especially those of lower socioeconomic ability, don't have computers. And what I've noticed is also a lot of people don't have printers in their home anymore. And so they aren't able to print things out if they can't get it mailed to them, especially at the height of the pandemic. Everybody had to rely on what was on computers. And while the younger generation, I think, does very well, my eyes start hurting and I like to have paper, and that can be a challenge for those that don't have printers. There's also access to certain documentation. I do a lot of domestic violence work, and very often, if there's a child involved in some capacity, there's Child Protective Services reports. Those reports historically have always been handed to the litigant and or their counsel. You get to review them, and you have to give them back. That's become a big challenge of reviewing those documents when you have these virtual protective order hearings. And a very large percentage of my clientele is non-English as a first language speaker, if that makes sense. So some of them don't English at all, and some of them are, international officers or something where they prefer and are more comfortable in Spanish, but and some of the technology gets or the translations get lost. But the interpreter access really varies depending on the court and that particular judge and the technology ability of the particular interpreter. I've noticed that there's, you'll have ones that are simultaneous on the screen. You'll have ones that have the language channel feature on Zoom, and then you've got the good old fashioned put it on mute, and the interpreter does it over the phone. So that's something that, can be a challenge. There's also a lot of positive things about it, but in terms of kind of having to overcome certain things, I think that is where they are. As counsel, settlement negotiations don't happen as organically as they used to. We used to sit in court and talk and be like, hey, let's talk while we're waiting. And so that is not as easy. Now we're all in a waiting room and we're sitting there checking email while we're waiting for, for us to get let into that room. And for me in my family cases, having to give certain exhibits in advance, even though you've exchanged discovery, clearly lays out, what your argument is. And so you have to give them in advance often. And that's a little frustrating. The study does point out for the court, in any case, that the average virtual hearing will take 34% longer than a in-person hearing. And so, that's obviously something that has to be considered in terms of the calendaring and how they set the dockets. So all of that being said, you had asked, what can we do to overcome some of these? And I think that there's quite a few things that can be done. The first is that we have to make sure that the court is setting virtual hearings for things that are appropriate to be heard virtually. And so it has become extremely convenient for scheduling hearings, pretrial hearings, settlement status conferences, motions hearings without testimony, things like that. Those have been amazing virtually. They're easy, they're quick, they save the clients money. They don't have to sit there. Before, where I practice for a scheduling hearing, everyone got there at 8:30 and it was a crowded courtroom where everybody was standing and waiting for them to be called, and your scheduling conference essentially took under 5 minutes. So now you can sit here, you can do it virtually. The client saves a lot of money. So determining where it really works is the best. I think also that the court should be aware that not everybody has access to the equipment that's necessary. And that's really something that's going to be important, and to not assume that everybody is sitting in a quiet room with internet and a laptop and all of that. So those are kind of things that we can do to make this go smoother.
Well, thank you, Pilar. And it is interesting to me. I'm removed from it, or have been removed in my position on an appellate court. But I do know something about how this can work, and there are variations on the theme. I have heard, I don't know, and you'll have to answer, and maybe others on the panel can also weigh in. When do these virtual hearings make sense, and are they universal? And assuming that is the case, are they universally approved? Or does it depend upon where you are, in what county, or Baltimore City, or what do we do to try to make it so that when under certain circumstances the hearing should be virtual and the other wanted to have in person? So what do you have to say about that? And maybe there'll be others who will want to weigh in as well.
So one of the things that I think is going to probably have to come down the pike for most courts, and I'm sorry to any of the administrative judges that may see this, but I think it's going to have to start becoming part of the DCM. I think that there's going to have to start being some kind of guidance, and so the differentiated case management system plan should outline these things in this particular county. I think that by and large, the hearings that don't have testimony, things that are just, pretrial hearings, things that now are working and we've realized work, I think those are those I think could be universal. I do think that it's important, though, that the court provide, now that we don't have as much, and once we move forward and we're not worried about, infecting each other as much, that the option to go in personally does exist for some. And so before, when it was in the height of COVID, we couldn't do that. You needed to keep everybody separate. But if we offer the opportunity for people, if they feel strongly about wanting to go there in person, that they have that opportunity, I think that could also help round things out.
Well, that's one piece of the puzzle, I think, but it's not an unimportant aspect to it. Okay, let's talk a bit about, and my apologies, folks. I have, my glasses are not working as they should, so I'm struggling to get my questions here. Well, let's see if we might want to talk a little bit more about not simply where we are with technology, and not, I haven't forgotten that one of the big issues here is if you have a client who does not have, as Natasha so well explained to all of us, if you don't have a client that's going to be able to be responsive to the technological issues that are relevant here in any judicial proceeding, or the uptick to that proceeding. What if are there any? And I'll just open this to the general, all four of you, if any of you has a thought about what Pilar was mentioning about the use of the when, the how, the why. When are there benefits? When are there not? When is it a real a tough one to do virtually? So it looks like everybody's here. Anybody want to chime in on that?
Sure. Could I go first?
Sure, Judge Wells.
I agree with you 100%, Pilar, that it depends on what kind of a hearing that's scheduled and whether that's appropriate for a virtual hearing or an in-person hearing would be more appropriate. I have the benefit of being here in the Circuit Court for Calvert County, and I talk to the administrative judge and the other judges who are here all the time about these issues. And I know the pandemic has changed the landscape for the judiciary in the sense that we understand now that virtual hearings do work. And I understand also that not everyone has access to the internet, especially here in Southern Maryland. There is a huge swath of the county south of here and then St. Mary's County. They don't get internet access at all. And so for those folks, they almost would prefer to go to court for some of their hearings. But just the connectivity is an issue, access to the correct kind of equipment that can make a hearing work. I've heard attorneys on the private bar and even some of the public defenders saying, and even the judges say on criminal cases, the client wants to be near the attorney because something might come up and they don't want to freak out on a virtual call about an issue that really could be very important to the client. So you have a group of folks that really want to come to court for their hearings. But on the civil side with settlement conferences, or status conferences, what we call them, just you kind of check in and tell the court where you are. That saves a huge amount of time. I've heard mixed things about settlement conferences, whether they really help the court and the parties work toward a settlement. And then the other part of this is that you have, as we're coming out of the pandemic, we don't have a uniform way to address, as you mentioned, virtual hearings, because if you want to have it in district court, you have to let them know. If you want to do it here on the circuit court level, each court makes their own rules basically about that. And for us on the appellate level, or at least my court, it's up to the panels now, each individual panel, to determine whether they're going to allow somebody to come in virtual, and they have to have a good reason. So I think, I don't know about DCM. I helped try to implement that and provide uniformity to the DCMs. I just think we're so close, or so just out of the pandemic, that all of these things are now coming to the fore, and some litigants are asking for it, some judges are asking for it. So I think it's a fertile ground for us to explore in how we deliver justice fairly to everybody. So I think the judiciary is open. It's just so new, and we're just so close to the end of the pandemic that I think a lot of people are afraid that we might go back to a full-time virtual hearings. I know a lot of folks don't want to do that. Mm-hmm. But there are a number of interrelated issues that I think we should all be working on to resolve.
I would add another
please
large segment that it's often forgotten, especially for us in the public defender's office, are our population of clients that are incarcerated. So there would be another member that would have to be, another stakeholder that would have to be part of the conversation would be, the Department of Corrections and Pretrial Services. And the challenge that we have in that the virtual hearings that we have, some of them are Zoom for government, but then there's also another system called Polycom. Now the problem with that system is essentially the client and the judge are on one system, and then the attorney is coming in on another system. So in those instances, I don't have the opportunity to speak directly with my client. And then there are times when my client and I are able to connect, but there's issues in terms of whether or not the communication is confidential, because my client is in an institution and is not necessarily in a private room. So there's definitely, as we talk about these issues, there are other stakeholders that are often going to come to the table so that we can ensure that we are truly giving individuals access to justice.
Natasha, could I just ask real quick, what was the name of the two systems? I know
Polycom.
Polycom. Okay.
Polycom. Yes.
Right.
The institutions use Polycom.
Okay.
And unfortunately, the attorneys are not able to connect directly remotely into Polycom.
Well, thank you, Natasha, because you've made a very important point here, clarifying the challenges that so many of your clients face and that you in turn face to be able to get them from getting closer to resolution of their matter. Amy, I know that we want to hear some of the voices that you've been working on, of the people that you've been working on, but do you have anything quickly to add to the conversation about virtual hearings? When, how, should they be done? Should it be universal? Does it make a difference? Do you have any thoughts on that first?
Yeah, thank you, Chief Judge. And when you asked that question, when do virtual hearings make sense? Immediately, my mind thought, when they provide meaningful access to justice, they make a lot of sense. And when they don't, we have more work to do. And I think that's why we're here tonight, right? So I know that we do want to get to be able to share at least one of our clients' experience at Legal Aid, but I have a client who is a minor, 17 years old, and couldn't be with us tonight because she is a minor, but is in foster care. And she had a hearing recently in a jurisdiction that's decided to stay virtual with no option. And she lives in a group home. And so her hearing was at 9 in the morning. It was 33 degrees outside. There's no private place she could attend the hearing. She stood outside on a cell phone with limited reception, shaking, trying to participate in her hearing. And the magistrate was going over a life skills checklist. And she see the checklist, was put in the chat. So she's on her device trying to use the same device to pull up the chat to see if she has these life skills. She only gets a hearing every 6 months. She used to be able to sit next to me in court, and we would go over this together and pass notes to me during it. And we can't do any of that now, like maybe some of our other clients can, who have multiple devices or at least on a laptop. So she can't even be inside in a building during her hearing. And that's not meaningful access to justice. And so in addition to the other very valid issues raised tonight, I think we just have to think very holistically about our clients. Do they have broadband access? Do they have multiple devices? Do they have a room they can participate in that's private? It just really looking at the low-income clients that Maryland Legal Aid represents in every jurisdiction and saying, does this make sense for them? Because if it doesn't make sense for them, it doesn't make sense for anyone.
Thank you, Amy. That is, you're spot on about the challenges with the population you serve and the limitations that they have to be able to get it done right, to have us get it done right for those clients. So did you want to introduce?
Yes, I think Bill Hall is going to, in a moment, queue up. We have a Montgomery County client, Dana, and she wanted to share her experience, was a little nervous to do it live. So we have the attorney that represented her, Alice Mutter, staff attorney, legal aid, who asked her a few questions. And
I am here with legal aid client Dana. And Dana, what did legal aid assist you with in terms of your legal matters? What types of cases were we involved in?
Legal aid assisted me with my custody case and also a protective order.
And so can you tell us a little bit about what effect COVID had on your child's schooling during the pandemic?
COVID had a big impact on my son's schooling. He actually was at home at all times because it was virtual learning.
And what grade was he in when this was happening?
The first grade.
And so with your son in virtual learning, what effect did that have on your ability to attend hearings that were being held on Zoom?
It made it extremely difficult because childcare was limited to non-existent.
And so were you able to attend any of these Zoom hearings from our office at Legal Aid?
I was only able to attend one hearing, but that was only because I was able to get my niece, who at the time was a sophomore in high school, also attending school virtually, to watch my son.
And so for your other hearings that happened, where were you attending those from?
I had to attend them from home.
And so what steps did you have to take to keep your son from hearing the court proceedings that were happening on Zoom?
I would have to first set him up for his day for virtual learning. And then I would have to instruct him that I was in a meeting and that it was very important for him to not interrupt. And then I would have to lock myself into a separate room, put in my AirPods, and attend the meeting by my phone, which was very difficult to maintain the conversation because I would have to stop, redirect my son, return back to the phone call, and I had completely lost track of what we were even talking about.
And so you mentioned that you had, when you attended from Zoom, you were on your phone. So did you have any other way other than your phone to attend these Zoom hearings?
At the time, that was the only device that I was able to use to attend the Zoom hearings. The only other device my son was using for virtual learning.
So the other device in your home, he was using throughout the day?
Yes.
Okay. And so were there, if someone was sharing documents or exhibits, what was it like being on your phone, which is a tiny little device, to view documents during evidentiary hearings?
It was very difficult. I wasn't able to, if someone were to pull up a document or present a document, I was not able to actually see the document because of how small the screen was, and you're not able to even zoom in while Zoom is happening.
And so even though there was an option for you to come in to the legal aid office, that really wasn't feasible for you given your child care situation.
Yes, it wasn't. It just simply financially, it was impossible for me to even afford childcare. childcare, if there was any available, it was extremely limited. So it was not possible.
Amy, I'm sure you have a reaction to that very vivid example of the many, many challenges that certainly that you had the overlay of the COVID and virtual classes and a little one at home and no financial or other ability to have childcare. I think anyone listening to that vivid example of how difficult it can be, and I'm sure it's not limited to many of the folks who come to legal aid for services. Do you have a follow-up to that at all, Amy?
Sure. I would just say that individuals that we represent that live in poverty have many hard choices to make every day and are exhausted from those choices. Should I leave my child at home? Will I go meet with a lawyer? Because I need to meet with a lawyer to keep my child safe from potential domestic violence. I mean, on and on. Our clients have $10. Should I spend it on rent or on food? And this example, this video shows you how many more difficult choices were presented to clients because of the shift to virtual hearings, much of which was necessitated. However, our clients were put in positions where they had new choices to make. How many minutes do I have on my cell phone this month? And should I use them for my divorce hearing or my foreclosure case or for my eviction instead of something else that I would have used those phone minutes for? Does my kid go to school today on the one device that we have, or do I go to my court hearing instead? These are choices that other individuals may not have faced and that our clients did face and unfortunately continue to face. And I think that's relevant today. And we're not in the heart of what we were in July 2020, but many hearings are still happening virtually and our clients still have limited access to broadband out in Garrett and Allegheny counties, many places on the shore. They still don't have many devices in their homes. They still can't do an e-signature like someone else may be able to. And so I think much of this remains relevant.
Well, it certainly does. And I hope that everyone who's, every panel member, as well as those who are listening, recognize that some issues are much more complicated than one might at first think. And hard, if not impossible, to make it an effective and easy presentation before a court in any fashion. So I'm going to turn it back to you, Judge Wells, to give us your wish list for how we might be able to work through some of these very serious problems to full and fair access to justice is what every one of you want. You want it for your clients, and Judge, you want the decisions to be fair and equitable in the delivery of justice and the rulings that the courts make. So we have a few more minutes. So if you want to give us perhaps a slightly broader challenge that we might have with both the courts as well as the members of the bar who are handling these, whether it's Natasha leading the charge in Baltimore City for her clients and for the many people who work with her in Baltimore City, for Pilar, same sort of challenges. And she mentioned, and I should have reminded all of us that some of the issues involve not just a lack of access to broadband and other meaningful ways to connect virtually, but also when it comes to language barriers. So we continue to have many challenges, and some of them have been more than mention, but I know each of you had to be as succinct as you possibly could be. So there's more to follow than this presentation tonight. But boy, we're getting to open the I don't know, the box that might have more positives and negatives than any we would anticipate. But to you, Judge Wells, what do you say?
Well, one thing that I had thought of in preparation for the meeting this evening was to look at the website and how a litigant, especially a self-represented litigant, might look at how it can work. And I think we do a good job of explaining under the e-filings tab, I think it is, how it works. It even has a tutorial. But I think we can do a better job of explaining these things to folks in an easy to understand way, maybe even with videos, and rather than have it printed, because we run into a language problem and a literacy issue. For the trial courts, and even for our court, I think notice of a need that if you tell us, and one issue that I just heard about here in Calvert County in the circuit court just came up yesterday, where there was a Ukrainian family that was trying to have a child brought here, and there was a whole host of complications. And it turned out that the dad and the mom, while the aunt and the uncle who lived here spoke English really well, the folks in the Ukraine, they didn't, and nobody thought to say, well, hey, maybe we need a translator for these folks to help them get through the hearing. And the judge who was handling it was really frustrated that he was just having a hard time communicating with the litigants. So I just think that, and I know it's difficult for some folks to foresee some of these problems, but definitely with counsel, if you tell us what you need, even if it's more time, more a translator, or any kind of an accommodation, I can't imagine, and certainly on our court, we would do our best to do that. But just giving us a heads up would be a really, and I'm certain for the trial courts, the same thing, just letting us know. I see Natasha's got a comment, so I'll let her speak. Yeah.
Well,
Natasha, yes, please.
You extended the invitation, so I have to bite. So I would give two examples. And when we talk about the shift in technology, there's also a benefit to the bench, and a small tweak may be at the beginning of these video proceedings to also add a comment in terms of the distortion that sometimes occurs when you're on video. And it's also the distortion from the perception of the litigant as to the judge, right? I think it's important that often when you're on video communications, you may have, just because the way the visual or the verbal is coming across, me as a litigant, I'm already in a place that I'm extremely stressed, and how I'm being perceived by the court, or facial expressions or comments that are made by the court. I think it's also important to note that from the perspective of the litigant. So maybe to speak, in the general announcements when the court first opens the session that is made, I think that's important. I also wanted to note that in terms of having it on the website, but it's also important to have a number where they can reach a live person, because especially for my clients, they not only have criminal issues, but they do have family issues. They do have issues in legal aid. And I think about the example of, like in the family law section in the circuit court here in Baltimore City, they had some self-help documents, but it was really not as effective until they actually got a live person who would assist them, anyone who came in with the documents. So I would say to you, even though you have a video on the website, it would probably be beneficial if there was also a phone number where people could call and engage a live person.
I certainly will pass that on to the persons who can make that more effective than I could. But I think it's a well taken observation, and I don't think it's limited specifically to Baltimore City. I think a lot of folks all over the state would prefer, in some instances, to speak to a live person. So one thing that I think you're right about perceptions, looking at these little boxes and how it all affects people's perceptions of others. And for myself, I think it's a work in progress for all of us, and we just need to be mindful of how it all comes together. And I just think judges, especially, just need to be reminded that maybe an announcement, like you say, would be a good idea. I hadn't even thought of that. And going back to district court, we would make announcements at the start of the proceedings to tell everybody, just give them a quick overview of what to expect. And maybe that's not a bad idea to do for Zoom calls too. So that's a really good idea, and I appreciate you telling me about that.
Right. Likewise, thank you, Judge, and thank you, of course, Natasha, for reminding us of that aspect of this whole process and how we need to react to it. Pilar, what's your thinking about where we are now, and what might we? This is a big question for all of you, really. What might we be thinking we can do to at least begin to make improvements? The judge is he's already on board as chair of the equity committee as well. I appreciate that. The rest of you may not know that he's chairing a very important committee and with lots of very, very good people. And this is an issue that I suspect has come up on more than a few occasions. And I'm going to count on you to go further with that. So, but back to you, Pilar, please. And then we can open to see if there's any questions from the chat room. Pilar?
Thank you, Judge Barbera. So what have we learned and how can we improve? So we've learned so much. And I think that the court and counsel and those that have been before the court over the last 2 years have really made enormous strides. When we first, March of 2020, when this first happened, everybody, I mean, don't get me wrong, we still say, hey, you're on mute, but it happens a lot less than it used to. People have really gotten a hang for the most part. When we first started, we had mediators, some of them retired judges, that were not all that big of fans of the technology, and it was just everything took forever. Nobody knew how to do anything. There was the guy that came up and said, I'm not a cat. There was so much that went wrong. And now you have, the same judges, these same, older practitioners that are just, zooming along and doing everything. And so everyone's really, I think the biggest issue was the willingness to do it and the appreciation that it was necessary in certain circumstances. We've learned that we can save, at least in what I do, which is family law, right, where we are in private practice and clients are paying for our services by the hour. We've learned that we can save our clients a considerable amount of money by not sitting in courtrooms waiting for cases to be called, by not traveling, by being able to be waiting for something and working on other things and can take that off of their time. So we've learned that it can be more economical to an extent, which I think really for those who are of limited means but using counsel can be very helpful. We've learned that we can have witnesses testify remotely that we never would have been able to have before, or we would have had to file special motions for telephonic testimony under parameters, but we can have experts testify, which saves the clients money. They don't have to travel. We can have hearings of, before it used to be one of those things where if you had a witness in France, well, good luck getting them here. Well, now we can. With a click, and so now we can have those witnesses testify that could be important. we've really been able to kind of get that moving. And that same study that I was talking about says 75% of the lawyers are happy with it, and I love it. I do. And if it weren't for the access issues with my clients and how it affects them, then I'd be all in all the time. But I recognize that it has their place. The virtual hearings have their place for when it's not limiting the litigants' access to the court, to justice, to a fair trial. And so what can we do to improve? And I think a lot of it is just being willing to listen and learn and improve upon what we've seen is going well, what's going wrong. I think also tolerance of certain things. You may be able to hear that there's someone knocking at my door. My 2 children are home. I locked the door so that they wouldn't interrupt me, but there's little hands knocking. And so I think that those are the kind of challenges that everybody's going to have. And I think that as long as, the court and other people are understanding of that, and we get that, we can all kind of learn together and have tolerance. And I think that also kind of maybe taking the temperature of the litigation or something like, or litigants, excuse me, and the bar associations, and having, see, and this is what happens when you get distracted with something that happens with your son. But if we could, keep an open mind in the channels of communication, so we can kind of address what is going on as things evolve.
Well, I thank you, Pilar, for those comments. We will not forget, though, that while there are opportunities to serve clients in one way that you just described to make it less costly for them and so on, we cannot forget those who have challenges every day beyond simply how do I get to find a lawyer? How do I meet with my lawyer? What do I say? I don't have a phone. What happens next? And I know we all have clients. You all have clients or did who are always asking what happens next. But for Natasha's clients, Amy's clients, and others that Judge Wells he's seen them. He's experienced it from the bench. It is a multifaceted issue that I'm so proud of the Bar Association for putting this panel together. Help.
So, Judge Barbera, I don't see questions in the chat yet. I would ask if folks could use the raise hand button if they would like to ask a live question, or if they would like to type their question to place it into the chat.
Judge Barbera, while we're waiting for questions, I just wanted to add to what Pilar was saying, that I think one of the neat things that we've learned that was unintentional was that, when a legal aid lawyer comes in a courtroom and has a client next to them, it looks the same as another lawyer with their client. But now some of our clients' challenges have been revealed to the bench and to other parties in ways that may not have been apparent before. And the empathy that has come from the clear lack of equity in that situation, I think is important to moving us forward in Maryland. And so I think that it has become really clear that people have challenges that are really real. Like, I'm in my car right now because that's where I can be, that's where my device is. I'm standing outside of McDonald's to do this hearing because that's the only place there's internet service in my neighborhood.
Mm-hmm.
And that's real. And so I think that how much we've learned from that as a collective can really take us farther if we use that going forward.
Those are great comments, Amy. We'll not just your fellow panelists and myself will take this home for further thought. And that's why some of the issues that we raised this evening are they're not easy nuts to crack. They're really difficult issues. And for those of you who are on the ground, Natasha and Amy and Pilar, not to exclude you, Judge Wells, but these are issues that come before you from a client's perspective. The judge, of course, has to react once it gets to a position where more can follow in the court system. But access to justice, equal access to justice is should be our mantra going forward. And I personally thank you for instilling a lot of good thoughts and information, and you've motivated me to do a couple of things myself. So
there's a question: are there parts of cases or types of cases that the panelists would like to see stay virtual going forward?
One person's nodding her head.
I will answer that. So I think that there are so many that can be, that remain virtual. I do think that there should be the option for those that want to appear in person to be able to do so. But I think that scheduling hearings have gone really well. That save the clients a lot of money. Pre-trial conferences, where the purpose of it for the most part is to turn in your pre-trial statement and get a trial date. Those are great. Motions hearings that are not going to have any evidence, that are not going to have any testimony or anything like that. Those are great. Motions for summary judgment, things like that. I think that those kind of hearings I think would be fantastic. The substantive ones, the pendite lite hearings, merits hearings, ones where people are testifying, protective orders, those really, I think that the virtual aspect of it served its purpose for the pandemic, but those are much better suited to being in person. But those others, very short, finite ones, I think would be really great, and I think have a potential to save the court and a lot of time in the clients, a lot of money.
And I would just say, from an access perspective, hearings where the client has major mobility issues and public transportation is insufficient. I mean, we have clients that have been able to participate that never did before because MTA Mobility didn't access their area because they had to take 3 buses and a train was late, and and they didn't have the funds for that. And so we're asking the judge to give them grace because they didn't have the money to get to court. So for those kinds of mobility issues, if a case can be held virtually and the client can participate, that's wonderful.
There was one comment, Judge, it said
Okay.
at the minimum, I think it would be good to give parties and counsel the option of filing a motion to request virtual or in-person hearings, depending on their specific set of circumstances and dynamics. But I'm not sure if anyone will want to comment on that.
I think in the criminal arena, we would agree with that, especially where there's no substantive evidence. But for us, one of the big pieces that would have to be resolved is for our clients that are incarcerated, and that whole confidentiality piece, being able to speak with them in a virtual space, but maintain that confidentiality. That's the big component that we are having challenges in resolving.
And I'll just say that I think what Pilar said is a good guidepost for us all about anything that can be resolved based on a legal argument or a scheduling conference. I can say that the judges here in the circuit court are doing that. I think it gets more problematic with cases like Natasha said, where folks are incarcerated or they just don't have the means to actually have a hearing, and that really poses a problem. And I just think that from what I've heard, the circuit court is doing its best to accommodate those folks, but it's definitely something that we should be open to considering. One thing that I will just say for Amy's benefit, when I was doing Senate cases, we had a number of kids who had physical challenges, and we were able to do virtual hearings before virtual hearings to accommodate them and the attorneys who may be at a facility someplace. So that definitely is something that judges should consider, not just the fact that folks might want to do it remotely, but they may physically have a disability that prevents them from getting to the courthouse. It seems like that would be a perfect case to do remotely.
Indeed. I think there might be one more, something that came across the screen. Shally, did you see that? We're almost at time.
I actually just posted this. I just asked, you know, taking all this information, what are ways that we as practitioners can help with this issue spotting and, you know, problem solving some of the issues, like Natasha, what you were talking about?
Well, the committee that put this program together deserves a lot of credit, as do the four of you, and of course staff that without the support of folks at, in the Bar Association, this would never have happened. So thank you to each and every one of you. There's a lot to think here about, and I am again facing four very intelligent, well-known practitioners for decades who have fought the fight and continue every day to do the best work they can do for their clients. So who could ask for anything more on that front? With that, I will call an end to this very interesting panel discussion. You all were great. As I said, I have a lot of food for thought, as I'm sure each of you does. So thank you once again, everyone. Thank you to the Bar Association. It's been a pleasure for me just to witness the good work that you're doing. So thank you.